If so, Jason Plotkin.
Delegate Valderrama and esteemed delegates, thank you for providing me the opportunity to testify today. My name is Jason Plotkin. I am the CEO of the Pinder Plotkin legal team. We are a law firm that represents injured workers, and we're also investigating opioid injury claims by individuals overprescribed by medical providers and pharmacists. I am testifying in support of medical cannabis as a workers' compensation benefit. It's an alternative to the opioid usage that can cause devastating side effects discussed here today. I have seen firsthand the toll long-term opioid usage takes on injured workers, hardworking men and women that work physically demanding jobs to make a living. They meet with me after being injured. Other than their injuries, many are in great physical and psychological states, easy to get healthy and get back to work. Unfortunately, many of these injured workers are prescribed opioids for pain relief. Those that are lucky recover quickly and stop taking opioids. Then there are those that are less fortunate. Those with significant lifetime pain-inducing injuries, they're left with few options to relieve pain and are typically prescribed opioids. So a lifetime of dependency begins. That dependency often leads to depression. There is some opposition to this bill that discusses the prescribing references to uncertainty of dosages and strains of the medical cannabis. As a workers' compensation attorney, I can attest that there is uncertainty across the board when it comes to medical treatment, causation of injuries, or necessity of medical treatment, including opioid prescriptions, that result in hearings at the Workers' Compensation Commission several times a day. The parties present evidence, including medical records from licensed medical providers, orthopedic doctors, experts, and a commissioner weighs that evidence as well as testimony to make a decision. Point being, there are checks and balances that are there to protect a lot of the concerns that the delegates have expressed today. Medical cannabis should not be more restrictive than opioid prescriptions. There's also been some concerns raised about workers being injured as a result of their consumption of medical cannabis. Respectfully, those arguments can't see the forest through the trees. I am much more concerned about workers being injured through long-term opioid consumption. Long-term opioid consumption using heavy equipment, other things they can do to be a danger to those around them. I have observed these vibrant injured workers slowly wilt away to shells of themselves. They wilt as the dosage of opioids increases and the psychological effects and erode their lifestyle. Some of them go to inpatient rehab centers paid for by the employer insurer. That's the insurance company for the employer that actually pays for it. Some clients will have to go to rehab more than once because as you bring your dosage down in rehab, you're slowly bringing it back up as you continue to be prescribed opioids. Maryland has medical cannabis as a legal form of pain relief. The bill that we are discussing today codifies common sense. Medical cannabis is legal. Injured workers are prescribed large doses of opioids. The opioid epidemic is undeniable, and it should be made clear that injured workers have the right to use medical cannabis. Thank you for your consideration.
Delegate Johnson.
Thank you, Mr. Chairman. I asked the question a little while ago. I'd like to ask you, where does the federal employers fall in this? Because like a DOD contractor, they get their money from the federal government. So would this jeopardize them getting contracts, receiving federal funds? How does all that play out?
That is under a completely different set of statutes that are federal. That's through the Department of Labor, Occupational Health, that's outside of the state of Maryland. The state of Maryland workers' compensation law does not govern federal employees.
Okay, thank you.
No problem.
Anyone else? Delegate Watson.
Excuse me, Delegate, I think you're muted.
Sorry about that. Just to follow up on Delegate Johnson's question, suppose, and maybe this was part of the conversation earlier, but I don't remember. Suppose it was a local non-federal employer who didn't permit or had drug testing and didn't permit cannabis use. For example, a police department or even some of our trade unions, in their training programs do drug testing and they don't permit cannabis. Would we then, if they were injured on the job, allow them to take advantage of this if this bill passed? I mean, I guess we would, right? But then it would be in conflict with their employer's requirements.
Well, I'll answer it in more of a general, because that's gonna be very specific to each employer's, handbook and guidelines. That is the same guidelines and handbooks probably preclude operating heavy equipment on opioids. They probably preclude a lot of other activities. Usage of medical cannabis would be just like any other prescription. Whether or not it's tested for would be an employer decision. There could be each employer may have a system in place where if you're injured, you are doing a different position, or you might not even be allowed back to work, like a physical limitation you already have. Or
So basically what you're saying is the law, if we pass it as is, would apply, but it would be up to the employee to determine whether or not they would actually use that treatment, if they know the employer doesn't permit cannabis use in some way, shape, or form.
Well, I would say this, I think there's probably other laws that would come into play as far as your concerns. Typically, when someone is injured and the insurance company works with the employer to see if they can return back to work while they're getting treatment, sometimes they're not able to because they have a modified or light duty based upon physical limitations. Sometimes it's because they're on opioids or other medication that they can't go back and do their job for a period of time. So I think medical cannabis would be treated much in the same way.
No, you have
Sometimes clients are kept out of work while they're recovering because they can't go back to their same job. If they have a lifetime injury, same as in opioids, if they can't return to their same job because of
I'm president of the NAACP.
Hold on. Mr. Little, I need you to mute yourself.
So if they are able to come back to work with medical cannabis, or not able to come back to work with medical cannabis, just like they couldn't come back to work possibly with opioids, there are provisions in the Maryland Workers' Compensation statutes to provide for suitable alternative employment through job replacement, where you'll go and to try to find a new career path, a new position. The goal is to find suitable alternative employment based upon their physical limitations, which could include medication use, opioids, medical cannabis, things along those lines.
Well, I would think it wouldn't. I would think that an employer that did not allow cannabis and did drug testing, and that was their policy, in their employee handbook, they would not create light duty position where an employee could use cannabis. But I mean, that's okay if if what we're trying to pass would allow for those individual employer decisions.
Correct. I don't see how it wouldn't.
Okay. And I just wanted to ask Delegate Valderrama why I've got this. This type of provision is now passed in other states. Is that correct?
5, yes.
5 other states. And is it passed in any other states with regard to non-work related injuries and health insurance companies? Do you know?
As
Or does
I
anyone know?
understand, if someone else wants to answer, but as I understand, they're all work-related injuries.
Okay. Thank you. Thank you, Mr. Chair.
Thank you. Delegate Howard.
Thank you, Mr. Chair. Hey, Delegate Valderrama, when you said 5 other states, when did it pass? If you don't know, that's fine. You can just
I'd have to look that up. for
Okay,
you,
that's
unless
fine.
someone here knows, but
Yeah, I'm just trying to look and see if it was like 2 or 3 years ago and sort of see what the trajectory of it was and what roadblocks, if any, they hit along the way. And also too, Mr. Plotkin, how would this affect, let's say, a Maryland-based employer working on a federal contract?
That would be governed by the contract as far as whether an employee could be using medical cannabis. Or there's probably, it would be based on the contract if there's a drug test requirement in there. It could be opioids, could preclude that same injured worker from going back to that job site.
So if I was a union worker and I went on from a contract that did allow it to a contract that didn't allow it, I could basically be missing out on work. I guess is what I'm saying, just based on the outline of the contract.
Well, I can't speak to that because the
Contract and what's that? I'm sorry.
I can't really speak to that specific contract, but if I could give you something similar, if you're injured and you have a physical limitation and you're a contractor, you might be on one job site able to do your job because the lifting is capped at, say, 15 pounds. You go to another job site and it's 20 pounds. That's outside your restriction. you can't go back to that job and the insurance company has to help.
With
find
all due
out.
respect, I mean, that's a lot different than what we're talking about here. And the federal government hasn't recognized any of this. And, you know, we have a lot of federal contracts and we have a lot of subcontractors to the subcontractor. We've passed many bills speaking to some of those issues. And what I'm trying to get at is how it would affect some of our workforce members, union and non-union, who would be going from a federal contract, even as a subcontractor, or a contractor to a federal contract from a Maryland-based business. I guess I said that a little backwards, but I guess what I'm trying to get at is that, and trying to see, and you're the attorney, so I'm asking you, is how it would affect someone that would be, for example, and I'm just trying to make it as clean and neat as possible, a union worker on a job that is a federal contracted job, you know, coming from a job that did allow marijuana usage, and now they're precluded from this other job that they could be at because of marijuana usage. I mean, I don't know. I don't know how you want to, if you want
Well,
to.
again, I think that would be specific to the actual contract, the contract language, what it requires, and the specific employer. They would have to.
So yes, they would be precluded from that work is what I'm getting at.
It would imagine so if the contract said they couldn't come, just like if they couldn't come if they were on opioids, possible.
Well, opioids are federally recognized, and unlike marijuana, I mean, they're federally recognized as health treatment. Fortunate or unfortunate, that's to the argument today. Okay, thank you very much. Thank you, Mr. Chair.
Right. If there's no one else, I'd like to go to Mr. John Kelly.